The judge is going to ask you tomorrow, how do you plead? Are you going to say anything beyond not guilty? Are you going to make a statement in court tomorrow?
No, I doubt it. I was just saying not guilty. I didn't do anything wrong.
Not guilty. That is the plea that Donald Trump says he will enter today at his arraignment this afternoon, adding that he will not make a statement during this initial court appearance. He does face 37 counts related to the alleged mishandling of national defense documents and an alleged scheme to conceal them from investigators. Joining us now is attorney David Schoen. He was one of Trump's attorneys representing him during his second impeachment trial. He also represented ex-Trump advisor Steve Bannon in 2022 after Bannon was indicted for contempt of Congress. David, it's really good to have you. Good morning.
Thank you very much. Good morning.
Would you agree that one of the biggest legal issues for both teams in this case as it proceeds is whether or not one of Trump attorneys, Evan Corcoran's notes and audio recordings are allowed in as evidence? You know Evan Corcoran really well. D.C. courts allowed that crime fraud exception to be pierced. But Florida could be a different story, right?
I think you're 100% right. I think it's a big issue in the case because it relates both to the return of the grand jury indictment and potentially to the trial. There's actually a relatively recent case, 2021 case from the 11th Circuit, which is the Court of Appeals that sits over this court in the Southern District of Florida. And that case had to sort of try to flesh out the, it's called in re grand jury subpoena. They had to try to flesh out the crime fraud exception because remember, one of the most sacrosanct privileges we have in the law is the attorney-client privilege. However, the law recognizes this crime fraud exception. There's two prongs to it. One is that the court has to be convinced that there was a conversation related to the furtherance of a crime or possible crime. That's a very low hurdle. But then the second prong is, was the conversation at issue related to the furtherance of the crime? The 11th Circuit sort of punted in that case, saying they didn't really have to decide how strict those parameters are regulated, but that traditionally the courts have been relatively less restrictive in showing that the conversation was directly related to the crime. The issue here will be Judge Howell apparently had Corcoran's notes, his private notes to himself, notes regarding his interactions with President Trump, turned over in wholesale fashion to the government. There's a question there. With any privilege that's pierced, the law is you only pierce it to the extent it's reasonably necessary. So if the turnover was far too broad or it was too broad, it could have tainted the grand jury process. If the grand jury was exposed to attorney-client privilege notes that really shouldn't have been turned over based on crime fraud exception, then the issue can come up again at trial. Assuming the judge doesn't dismiss the indictment based on this taint or alleged taint, then it would come up at trial again, whether they're admissible. And if they are admissible, the flip side of that is it opens the door for Evan Corcoran to testify. I think his testimony, quite frankly, would be favorable to President Trump in explaining his notes, as damning as they might seem now on the face of them. I think his testimony would be favorable to President Trump.
Dave, can I ask, I've been listening to your response to this indictment and some of your interviews over the course of the last couple of days. I want to play some sound from the former president's former Attorney General, Bill Barr, and then get your reaction to it. Take a listen.
If even half of it is true, then he's toast. I mean, it's a very detailed indictment, and it's very, very damning. And this idea of presenting Trump as a victim here, a victim of a witch hunt, is ridiculous.
David, you haven't presented him as a victim of a witch hunt, but you have said you believe there are significant holes in an indictment that the former Attorney General seems to believe is pretty rock solid. What are they?
Well, first of all, my issue with former Attorney General Barr is I think that every lawyer has an obligation to point out the presumption of innocence. To the extent he says, well, if this thing is true or even halfway true, it's very damning. It's a serious indictment. There's no question about that. And every federal criminal case or other criminal case has to be taken seriously. But there are defenses to the case. And I don't think it's fair to judge any case based on the indictment. It would be like watching the prosecution put on their case without any cross-examination and saying, well, he must be guilty. So the allegations are serious, but they're just allegations at this point. Listen, I think there are plenty of defenses, including it was a very interesting choice to choose the statute of the 31 counts, 18 U.S.C. 793E. I think they did that in order to get around the idea of whether the documents were classified or declassified, because they don't have to be classified for one to be guilty under that statute. However, there are several elements to the statute, including whether the person was authorized to have the documents. And this is where their defense of Presidential Records Act is going to play into it, and so on.
What is the
there are a lot
Presidential
of legal
Records Act
issues
have
to be
do with
fleshed
this?
out.
Can you just say, I'm very curious, you've mentioned
I
this
think
before.
Yeah.
It's not cited in the indictment. The
Yeah,
Presidential Records Act has
yeah.
nothing to do with other agency documents that were taken by the president. He has no record of saying these agency documents are my personal records, even if he did try and do that. So where's the PRA actually come into this here as a defense?
Right. I actually have not emphasized this point. I've heard many other people emphasize it. I think the reason it's gets less emphasis than people were guessing before the indictment came out is, again, because this classified element isn't a part of it. People generally were talking about that before because of the president's unilateral right to declassify documents when he's in office. However, I think it's relevant here based on the willfulness prong. That is, did he know, should he have known that he was doing something prohibited by the law, given the reading of the Presidential Records Act that his advisors have given him? I also think it goes to the first prong, whether he was authorized to have documents in the first place. You know, one thing that's never really pointed out these days is traditionally, and again, you may say it's not directly relevant, but I think it's somewhat relevant, is that the tradition has been former presidents get regular intelligence briefings even well after they're out of office and all that. So one thing we have to remember is there is something special and unique about the position of the presidency. Whether it's a complete defense or not, it's a different question. There's something to remember about that.
That's true, but they certainly have no right to show or talk about those national top secrets in front of people who have no classification, which is what's alleged here in terms of the audio of that meeting with the authors writing on Meadows. Let me just ask you another defense that has been made by the president's allies. Jim Jordan made this repeatedly with Dana Bash on Sunday morning, citing a 1988 Supreme Court decision, Department of Navy versus Egan, which essentially says the president has the authority to classify and control access to information bearing on national security. The Constitution gives them that power. But that's while they're president, not after, correct?
Yeah, that's correct. You know, that's the classic case that everybody talks about in this realm. But I'll tell you this, there is a very interesting case. I mean,
David,
some people have
I
talked
just want to
about...
stick on this case because it is what the president's allies are using so much.
Sure.
To argue it in the way that his allies have been arguing it, that it gives him this right post-presidency, is an inaccurate reading of that majority opinion from the Supreme Court, right?
Yes, I think that's right, that it gives... Look, Egan talks about when a person is president. However, I do want to stress, there is a case from Amy Berman Jackson. You may also have had someone talk about on your show, Judicial Watch case from 2012, that has a lot of language in it that talks about the unique power of Bill Clinton at that time, when he's president and after he's president, with respect to not just personal records, but presidential records. There are very interesting issues that really have not been fleshed out here, and I think we have to give them a chance to play out. We haven't seen this kind of situation before.
Can you just very quickly, related to the Judicial Watch case and the Bill Clinton case specifically, those were about recordings that he did in what he said were a personal capacity while he was president, which I think would fall under the definition in the Presidential Records Act of personal records. How do you feel like that bleeds into this specific case where, again, you made very clear you haven't been citing the PRA or Presidential Records Act? That's about personal records. These are about agency documents that the president took with him. So how do those two... What's the language in there you think that applies here?
Well, I have the page marked with the language specifically when Judge Jackson talks about, first of all, the lack of judicial review generally for issues that come up under the PRA when NARA makes their claims and all that. But here's where I think it's relevant, whether it directly applies or not. I think it's relevant to the willful prong. The question here is under 793E, one of the questions is, the third prong, whether the person being charged willfully did it. That means did something he knew was prohibited by the law. Now, you're going to say to me, well, you can hear from the tape, it seems that he knew, what he was doing. He wasn't allowed to do it and so on. Tapes can be cross-examined, notwithstanding what many of these commentators say. Tapes can be cross-examined. What were the circumstances? Exactly what was the rest of the conversation, and so on. Again, we have to hear from the defense about all of these things. But I think it plays into what was in his mind, what he understood from his advisors, right or wrong, about what he had the authority to do with documents.
David Schoen, and you make a good point. Innocent until proven guilty. We have not seen or heard the full, fleshed-out defense of the former president at this point in time. Appreciate your time, sir, as always.